Welcome to Mindful Live 92. Wow, yeah, Mindful Live 92. It is the 10th of June. Wow, the year is rushing away with us. The 10th of June 2022. Welcome to Mindful Live 92. I am your host, Nathan Springer. It's a pleasure to be here. And we're discussing tonight, this evening, the current affairs and news of the day as far as we can see it. And there are various topics that we may cover tonight, but we're beginning with one of the major stories that at least I did on my YouTube video today. Well, according to when you're viewing this, if you are viewing this on repeat on YouTube, I am streaming right now live on TikTok and on YouTube. But if you are looking at this on the live stream, feel free to head over to YouTube and subscribe so that you can catch the lives on repeat whenever you like to. You can just go back and look at it again. And if you are looking at this currently on YouTube, make sure you hit that like button, drop a comment, make sure you're subscribed. If you feel like it, hit that notification bell too so you know when next the video jumps out. Good night, Fearless. So, the first thing we're talking about, and this is, as it were, a pet issue of mine, if we're being honest. I have been talking about this issue for a little while now. It's something that has been on my radar, as it will, because I find it very interesting, and I find it kind of pertinent to the nature of our country and the legal system in our country. So, yeah, we're going to talk about the bail bill that was recently overturned by our appeal court. But our government has been insisting that no, they cannot live like this. They cannot live like this. We cannot allow the bail bill to not stand. We must have it that murder accused people cannot access bail. The government insists on that, so they are taking it straight to the Privy Council, and that's where we are currently. And I found this. We spoke earlier in previous videos about the difficulties we have in choosing where our highest court is, and like when I look at this, there's a bit of embarrassment in this when I think about it. When my perspective on this is, I feel like there is a bit of embarrassment in this. We have a squabble in our nation, and if you listen to the squabble, if you listen to the nature of the squabble, what we are squabbling about, we are squabbling about the nature of our constitution to some extent, what our constitution says about something. And if we're having this kind of discussion, do we have to go to British law lords for them to draw a conclusion on it? Doesn't that have a kind of slight embarrassment feel? Or is that just me? Like, if we are an independent nation standing on our own, how do we go to Britain to solve an issue like this? An issue where our judiciary and our parliament is at loggerheads, and we're going to the English for them to tell us, what we should do. Yeah, that does have a little belittling feel in it, at least to me. I don't know how you think about it, but yeah, I have some of that. And speaking about colonial holdovers, interesting, part of this literally has to do with a colonial holdover law. Basically, let's get into it. I'm not going to get fully into detail. If you want to get nice and deep inside of it, you could check out the YouTube video I did on it, my last YouTube video on this whole incident, and it gets a little deeper into it. So, the Privy Council, and I must admit, the Privy Council has one of the best summaries of the matter. The Privy Council gives us a nice, concise summary of the matter as it stands, why the matter is as it is right now. So let's see if we could read that and make sense of this. The issue in front of the Privy Council, the central issue is whether Section 5(1) of the Bail Act 1994 is inconsistent with the Constitution and therefore susceptible to being struck down. So what's the purpose of the CCJ? Fearless asks over there on TikTok. Well, the CCJ, the intention of the CCJ is to replace the Privy Council, but in order for that to happen, we must have agreement. We spoke about this before. We do not have agreement on replacing the Privy Council with the CCJ in Trinidad and Tobago. So if we don't have agreement, then it cannot happen. And that's that. So, yes, the facts, these are the facts of the matter according to what is in front of the Privy Council. Mr. Charles and 5 others were charged on 5th December 2010 for the murder of a man and kept in custody on remand from that date pending trial. From that date, pending trial. Mr. Charles' preliminary inquiry commenced on 16 January 2012 before the Chief Magistrate and was halted on 3rd April 2017 when the Chief Magistrate was elevated to the High Court. So, Mr. Charles, by 2017 there, Mr. Charles is already in jail. Mr. Charles is already in jail for a good 7 years. Already in jail for 7 years. By 2017, when his case was halted in front of the first Chief Magistrate. 7 years he's in jail. The acting Chief Magistrate that replaced the previous Chief Magistrate, because the previous Chief Magistrate was elevated to the High Court, was it? Yes. And the acting Chief Magistrate decided that the preliminary inquiry should be heard de novo, a whole new preliminary inquiry. The new PI was discharged on the 21st of May 2019 on a no-case submission, and Mr. Charles was released from custody 9 years after first being detained. So, this first bit here is the background to what we are talking about now. This is the case that brought this whole topic, this whole area into focus. This man was charged with a crime, with murder in 2010. His case went on till 2019, and in 2019, it's not like he went through the full trial and a jury found him innocent or something like that. The case was thrown out on a no-case submission. So, you're considering that a man spent 9 years in jail for what the court system deemed to be no case. They had no case, and you spent 9 years in jail for it. That's the background of this. And he spent 9 years in jail. He had to spend that 9 years in jail because he was charged with murder. And once you're charged with murder under the bail bill, you cannot request bail because you cannot get bail. Murder accused cannot access bail under that Bail Act. Talk Heavy says, remember you're innocent until proven guilty. No disclosure for the victim's family. Yeah, you're supposed to be innocent until proven guilty, and this is the very issue that this whole situation raises. On the 6th of February 2020, Mr. Charles brought a constitutional motion for a declaration that Section 5(1) of the Bail Act, which provides that bail cannot be granted in the case of murder and certain other offenses, is unconstitutional. The act has been passed under Section 13 of the Constitution. All right. Let's see if we can head into those two pieces of the Constitution. So, the judge dismissed the motion initially, but then when it went on, the Court of Appeal allowed Mr. Charles's appeal, holding that Section 5(1) of the Bail Act was unconstitutional because, 1, it derogated from the fundamental rights and freedoms in Sections 4 and 5 of the Constitution. And I have our Constitution pulled up. I like to have our Constitution pulled up. These are supposed to be the words that our country is governed by. So, in our Constitution, Section 4 and Section 5 of our Constitution, that deals with, as said, the rights and freedoms that we are granted. Scroll down there to the Section 4 and 5 of the Trinidad and Tobago Constitution. Where is it? Grand. It is hereby recognized and declared that in Trinidad and Tobago they have existed and shall continue to exist without discrimination by reason of race, origin, etc., etc., etc. The right of the individual to life, liberty, security of the person, enjoyment of property, etc., etc. All of that good stuff. So, in other words, you cannot just grab a person up from the street and deprive them of their right to liberty, their right to freedom of movement and freedom to express themselves, etc., etc. So, all right, that's part one. That's the section 4. Section 5, except as is otherwise expressly provided in this chapter and in section 54, no law may abrogate, abridge, or infringe or authorize the abrogation, abridgment, or infringement of any of the rights and freedoms herein before recognized and declared. So what this section of the Constitution says is that Parliament itself cannot pass laws. Good night, Halley 59. Parliament itself cannot pass laws that go against these freedoms and rights that our Constitution have granted to our citizens. So if Parliament passes a law that goes against these freedoms, the law is against our Constitution. Parliament cannot, and in this section, part F, Parliament cannot deprive a person charged with a criminal offense of the right, and you go down to part 3, to reasonable bail without just cause. So our Constitution has in it that Parliament cannot make a law that deprives a person of their right to access bail if they are on trial. That's in our Constitution. But here's the thing. Our Constitution has a little clause in it in section 13 that says, okay, well, you can actually take away someone's rights as said in the Constitution. So those freedoms and rights you have in the Constitution are not without limitations. They are not limitless. They can be acted upon, they can be removed, they can be abridged, but according to section 13 of our Constitution, the only way that can be done, well, the only way that can be done is why you hear very regularly, you hear in Parliament, they're talking about the special majority, because first up, you need that special majority in Parliament. Before you can take someone's rights away, you need a special majority. Now, I find that still kind of strange that whether you're a majority or not, you shouldn't be able to take anyone's rights away, but I understand that they may be thinking in case of emergency, etc., etc. But either way, although the Constitution does allow the Parliament to take away some rights, there's a little caveat inside there. Section 13 of our Constitution acts inconsistent with sections 4 and 5, the Freedom and Rights Acts. An act to which this section applies may expressly declare that it shall have effect, even though inconsistent with sections 4 and 5. So you can make an act from this section, even though it's inconsistent with the previous sections. If any act does so declare, it shall have effect accordingly, unless, here's this is the very important part, unless the act is shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. So there is a limitation there. Whether you have the 3/5 majority or not, first up, you must ensure that the act must be shown to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. All right, so after we get that little constitutional lesson here, now we go back to the Privy Council to see the issues at hand. The appeal court, our appeal court, on 3 grounds basically throughout this bail bill. One was it derogated from the fundamental rights and freedoms of section 4 and 5. We read that already. 2, it was not an existing law and therefore it was not saved under section 6 of the Constitution. So what they're talking about is part of the government's reasoning that they're using. They're saying that this was saved law. What they mean by that is there's a unique bit of law in Trinidad and Tobago, and I think in Barbados too. I'm not sure anywhere else in the Caribbean, but I wouldn't doubt there may be other places with similar such laws. But the savings law, the idea of it is we had laws before we got our constitution. Before we made our own constitution, when we gained independence, we had laws already. The British were ruling us. We already had laws in Trinidad and Tobago. And to avoid conflict in the movement between colonialism and our own independence with our constitution, there was a part in our constitution that basically says any law that was there in existence before the writing of our constitution cannot usurp those laws. Those laws are saved. And they were making an argument that this was a saved law because it existed before 1976 when our constitution came about. But the appeal court said, nah, that's not true. And we'll see that is really and truly not true. One of the biggest problems with this is the very low detection rates. Yes, that is the main problem. And part 3 of why the appeal court threw out the Bail Act, it was not protected by virtue of being passed under Section 13 because the derogation was not shown to be reasonably justifiable in a society that has proper respect for the rights and freedoms of the individual. So our appeal court said that this thing, by not giving someone the right to request bail, that cannot be reasonably justifiable in a society that has proper respect for the rights and freedoms of the individual. I find the dress code thing to be annoying. What dress code thing are you talking about? We know whether a person is guilty or not, or even most likely to be guilty or not if investigations are properly done. Correct. That is true. Now, let's see the arguments. So this is the whole position that we find ourselves arguing this in front of the British people, and we are the arguments have begun. Let's see what the arguments look like. Privy Council told Parliament did not trust judiciary on bail. So the argument that the state is using is partly that the Parliament didn't trust the courts, basically. In his submission before a panel of 5 Privy Council judges on the first day of a 2-day hearing, Knox, who is the attorney for the government, said the Parliament could override powers and freedoms provided for under the Constitution, and when enacted the 1994 Bail Act, it did so because of concern with the rising crime situation in Trinidad and Tobago. He said at the time Parliament was concerned about the rise in crime. And when the act was passed, no one raised an alarm that it put a ban on those charged with murder applying for bail because granting bail on a murder charge had never been done before. Now, this is the thing I find so strange. I don't understand this argument. For those of you who may have seen my video for the day already, this is the thing that keeps confusing me. The government's attorney is arguing that they were concerned about crime, so they passed the Bail Act. But in the same argument, he is saying that before the Bail Act, no judge gave bail for murder anyway. So if no judge gave bail for murder anyway, and you pass a law that stops the judges from giving bail for murder, the law has no effect on reducing crime. Isn't that a confession that you passed a bill to make it seem like you're doing something about crime that literally has zero effect on crime? You're saying no judges gave bail for murder before the bill was passed anyway. But the bill was passed so that we will stamp out crime. We were worried about the increasing crime. So what is the bill going to do differently? How is the bill going to do something differently? I would like to see how the Privy Council law lords rule on this, because I have to assume that I am missing a piece of the argument here, because that does not make sense. Knox said the law was introduced to curb crime and disorder and maintain the common position as it related to offenses that carried the death penalty. Bail was not being granted because it was thought it couldn't be, and no one saw any problem with that at all. That is because of the high crime rate. The public has the power to decide which laws are passed. He said there would have been an outcry if someone said the High Court should have discretion to grant bail for murder. He also suggested that at the time, the thinking of the parliament was it did not trust the courts because at the time, people on bail were, were committing crimes causing serious concerns. Now, someone explained this to me, right? Someone of you out there who is more intelligent than me would have to break this down for me. The state's attorney is saying that people on bail were out there committing crimes. They were concerned about that. That's where the concern arose. People on bail were out there committing crimes. But at the same time, he was saying that no one before the Bail Act granted murder-accused people bail. So, how could you say you don't trust the judiciary because they're granting bail and people on bail are committing crimes, and then say that they never granted bail for that specific crime anyway? I am not understanding how that is a logical series of thoughts. Parliament is saying, this is the attorney for the government speaking here again. Parliament is saying, I do not trust you, the court, and I am taking some of your jurisdiction away. Here you had a crime problem where people on bail were committing crimes before the Bail Act. There may have been a window of opportunity to grant bail, but it was never done. I don't understand how this makes sense. I don't understand how that makes any kind of sense. All right, let's go down there. In his opening remarks, resisting the state's appeal, former Attorney General Anand Logan, who is fighting the case opposite to the state, just by the way, former Attorney General Anand Logan, senior counsel, Silk out there, said it was startling to hear the state's submission that the law prohibiting bail was born out of a mistrust of the parliament for its own judiciary. I agree. That is a bit strange. That is a bit strange for you to admit that this law came to being out of mistrust between the parliament and the judiciary. That is, I'm not sure that is a positive admission in this case. He says, I take umbrage. The fact there may be a public concern with the way the courts decide cases is not only unique to Trinidad and Tobago. Logan maintained the courts were not a populist institution. He said to equate public concern with a proposition, there was mistrust of the legislative arm to the judicial arm to justify an encroachment on the court's jurisdiction was alarming. Now, here's what he's saying. Good night, stars, Juliet. Here's what he's saying there. The judicial system, the court system, the courts, the laws, the judges, they are not a populist institution. The nature of these laws are not made with the intention of being populist. It's not like a court case is determined by what the most people in society say. You don't take the court case and beam it over the television and then have an election and vote for what the verdict is going to be. That's not how court cases are decided. Yes, I did, Hallie. That's not how court cases are decided. Court cases are supposed to be decided on the merit of the truth and fact of the case. So the former Attorney General is making that argument. For you to say that the public mistrusted the judiciary, that isn't an argument. For you to say that the public had a problem with the judiciary, that is not an argument. And then to take that to say that you had mistrust in the judiciary, that doesn't work. For you to say that you had mistrust in the judiciary, you must have a good reason for it. And a good reason for it isn't that the public had a problem. You have to get specific with that. And I kind of agree with the former Attorney General there. I agree. They went on with some more arguments there, but that's the gist of the argument as it stands. Bro, all the Caribbean rule under the British, and that is the law. It never changed. I do not know what you're talking about in specific there. But as it stands, we have a ruling from our Court of Appeal. The intention is to carry it now to the Privy Council to see if the Privy Council is going to change that ruling. The government is determined, saying that this bill is essential for the safety and security of this country. It's essential to make sure that the country is secure. I actually don't agree with that. And let me go back to our next piece in this. There's one more piece in this I'd like to highlight. Something I found very interesting as I remember that. Earlier, Knox, in defending the enactment of the Act, said it was not enough to say Section 5 was unreasonably unjustifiable in a society that had proper respect for the rights and freedoms of the individual, as the appeal court held in the ruling of Achille Charles, a former murder accused who challenged the bail prohibition. Knox said the question had to be determined whether the Knox said the question that had to be determined by the law lords was if the law was capable of justification. So, here's the little word game difference that is being attempted to play there. Yo, good night, Ria. What's up? What's the good? Good. Nice to have you in the house. We inside. The word game that seems to be playing there is he is saying that he does not want this Bail Act was a stopgap measure to make up for the slow justice system. But that doesn't help. We'll get into that just now, Tony, the ambassador. But he is saying there that he doesn't want the law lords in Britain, he doesn't want the Privy Council to just look at whether it was unreasonably unjustifiable in a society that had proper respect for the rights and freedoms of the individual. In the individual case of Mr. Achille Charles, he does not want them to look in that individual case. No, not there. Don't look to see if it's justifiable there. Look to see if the law was capable of justification, as in if there was in any situation where you can see it being justified. But here's why I have a problem with that. The statement that is in our Constitution that they keep talking about here, it must be reasonably justifiable in a society that has proper respect for the rights and freedoms of the individual. So, let's get some things clear. As it stands, putting a man in jail for 9 years for what you determine to be no case is not reasonable and is not justifiable in a society that has proper respect for the rights and freedoms of the individual. You cannot justify that if you have respect for someone's rights and freedoms. In a society with respect for rights and freedoms, you cannot justify jailing a man for 9 years, 9, 1, 2, 3, 4, 5, 6, 7, 8, and you still have another year, 9 years. 9 years, you cannot jail someone for 9 years and say that you have no case after the 9 years. That is unreasonable and unjustifiable. I think rightfully so. And although the state's attorney is saying that you cannot look in the, he of course is saying you cannot look in this specific case, because in this specific case, it's obvious that it's unreasonable and unjustifiable. So he's saying, no, let's not look at this one specific case. Let's look in the broad aspect and see if it can be justified, potentially, possibly. I understand that, but I disagree, because there's a word inside there. The rights and freedoms of the individual. You see, this little bit in our Constitution is an individualist piece of law. It says, if this isn't reasonably justifiable, if you respect an individual rights and freedoms, then it cannot be a law. And Mr. Charles is an individual. You cannot say, okay, let's bypass looking at that individual, but we're considering a law being being justifiable to the individuals in the society. If it's unjustifiable to one individual, then it's not justifiable to the individuals in the society. I can't understand how he's trying to play that little word game there. No, not if it's unjustifiable in that case, if it's possibly justifiable in some other case. Bro, do you know in America how many, oh God, what does that have to do with this, Ms. Stars Juliet? What does that have to do with this? If innocent people go to jail in some place in the world, does that mean that we should jail innocent people here? I do not understand the point of that. I really like that has zero relevance to anything. Can you imagine? Can you imagine? Back in the days of slavery, you walk in and meet a slave being whipped till an inch of their life, and you tell them, you know, many slaves there are all over the world, but that really doesn't help. I don't understand that. But yes, that's the present case as it stands. No, I am not saying that, bro. Okay, well, you can explain yourself. I don't mind. Explain what you mean more directly. That's the case where it stands. At the Privy Council, with our government arguing that they didn't trust the judiciary, so they had to take it out of their hands. I don't understand that. As far as I could see, their argument has a lot of holes logically, but I guess the law lords out there in Britain will come back and tell us if it makes sense or not. But I was reading a case down here with one of our local favorite judges who is he's always out here talking. He always has a mouthful to talk about. And the thing is, the case is so interesting. When I read this case, my eyebrow just kept going up higher and higher and higher. Like, what? Wait, what? Wait, what? They're just afraid of those currently in jail. Possibly, very likely. But you have to do something legally. Even if you know someone is a horrible person, if you break the law to get that horrible person, then you are opening the door to break the law for some more. Wow, I am a poet. You're opening the door to break the law for some more. But yes, one of our local judges had a lot to say on a recent case that he ruled, and if people in prison calling shots in jail, imagine free. I agree. Judge slams greed gullibility as Princess Town woman agrees to pay 1.2 million to neighbor allegedly duped. A High Court judge mints no words in registering his disquiet at a loan arrangement between a Princess Town housewife who was allegedly duped into lending her neighbor, listen, over $1.3 million over almost 2 years with a promise she would get back big interest. On Thursday, the neighbor who received the money agreed to a settlement to repay $1.2 million with $15,000 to be paid immediately. From July 1st to November 1st, the neighbor will pay $15,000 installments and in December repay $1.1 million. However, the civil claim for restitution was expected to go to trial on Thursday. Instead, after Justice Frank C. Prasad refused a third adjournment of the trial because the defendant was ill, he allowed her attorneys to speak to her client so the matter could proceed. So after 2000, she realized she ain't getting none back. Listen, the story juicy. Shortly after that, the judge was told the parties were in discussions and they made that agreement. In signing off on the consent agreement, Sipasad made it clear his court will not entertain claims based on unconscionable terms. He said the case raised alarm and the pleaded facts demonstrated a level of greed and gullibility. Fully agree with that, though there stars Juliet. Too many people do get locked up for the wrong reason until they're proven, well, I guess proven innocent. But yes, I agree, many people are locked up for the wrong reason. The judge went on, there's a saying, if it is too good to be true, it is too good to be true. Common sense must prevail at some time. Compassion should never be allowed to overcome common sense. This ought not to have happened if common sense was exercised, the judge said. He also noted aspects of the loan agreement between the two neighbors, saying in no reasonable society can you expect to lend 30,000 and get back 250,000. Now, that statement there gives a peep. That gives a peep. It gives a peep. In no reasonable society can you expect to lend 30,000 and get back 250,000. So that right there gives a peep into exactly why so much money was lent. Sipasad said currently when there are economic constraints, the likelihood of exploitation of people with financial means was great. He said with fraud and the increased stupidity and gullibility will be exploited, leading to the legal system being inundated with similar claims for restitution. Sipasad said the claimant in the case, a housewife, now here's where it get really saucy. The claimant in the case, a housewife who took the money from her daughter's savings accounts initially without her consent, without their consent. So mom's cleaning out her daughter's savings account. Mom's was clearing out. Mom's was clearing out baby girl savings accounts little by little without her consent. Was unfortunate. The defendant has agreed to settle by paying back a substantial portion of what was loaned. Hopefully there will be compliance. He was harsh in his criticism for what she did, saying the reckless use of her daughter's money demonstrated a level of greed and gullibility. So mom's thieving daughter money because she greedy and gullible. Well, she could only be charged, I guess, if the daughter presses charges. It's up to the daughter to press charges. He also said the defendant was lucky no criminal fraud proceedings had yet been engaged, although in the pleadings the housewife said the matter was reported to the fraud squad, though her neighbor said the police are yet to contact her. So the neighbor hasn't yet been criminally charged. In the lawsuit, the Princestown housewife said the neighbor first came to her in March 2017 asking for money to pay taxes to access a US $20 million medical negligence court award from the US for her husband's death. Well, therein is the trick. I need a little money. I need to pay some taxes. I have to pay the taxes first, but I have a US 20 million coming in. Some insurance money. And when I get it, I'll pay it. When I get it, I'll pay you back. I'll pay you back. The neighbor also provided documentation from a US bank. She said one of her daughters did not want to lend her the money, but the neighbor threatened on numerous occasions to take poison and even hurl herself in front of a truck to end her financial worries. So the neighbor threatening to kill herself if you don't lend her a couple million. But she's threatening to kill herself while promising that she will pay you back too. Talk Heavy is asking if she with BLM. Oh gosh, you like too much bacchanal out here. Oh. In her defense, the neighbor denied the claims. Instead, she claimed the proceedings were filed to extort money from her, other than receiving US $700 and $75,000, from which $35,000 was returned. The neighbor said there was never any agreement to borrow any money. She admitted that she had been successful in a medical negligence case in the US, but said she never said the court award was to the tune of millions, nor did she know about a lotto win. Oh yes, I forgot to read that piece too, because She said also the neighbor also claimed to have won a $28.1 million NLCB Lotto jackpot in 2018 and asked for funds to pay the taxes to receive the windfall. Listen, I don't understand people and this gullibility. Give me money to pay the taxes so I can get money. Oh geez, oh geez. And the neighbor saying that she didn't know anything about that. Of course, she also accused her neighbor of coming to her home and taking personal documents, including banking records, without returning them. If she fails to pay the installments by December, the entire balance will be due, Sipasad said. Oh, yes. So, Bacchanal out here. As I was in the whole court system business, I just saw that story and I said, listen, I have to get in on some of that. I need to play a little lotto tomorrow. Yeah. And then when you win, I will come and borrow some money because I have a windfall I have to collect from a Nigerian prince. I have to pay some back taxes first though, and yeah. How's she paying that back? That is I was just thinking about that, Mr. Interesting. I was just thinking about that. How is she paying that back? I don't know. I really don't. Alright. Ria, you're in the house. Are you up for having that discussion now? Still interested? The real victim here is the daughter. Yes! The real victim is the daughter. The daughter is the one who lost the money in it. Because moms didn't even have the money. Moms was lending other people money. Imagine that. Moms lending other people money out here. She didn't even have the money herself. Tough. Now, how the daughter taking all of that? I would to be a person in that crowd there to see how the discussion goes between daughter and mother at that point in time. Oh, that would be interesting. That would be so interesting. Bro, how do you deal with a parent who does that? I don't even know. Like, what do you do there? Your guess is as good as mine because I honestly don't know what you do with a parent in a case like that. If your mother did that to you, 1.3 million. You feel you're forgiving that easily? You feel you could forgive moms that one? If moms lent out a little 1.3, it's 1.3 I believe she lent out. Was it 1.3? And it's just that she's only getting back 1.2. They agreed to repay 1.2, but she lent her neighbor over $1.3 million. Over 1.3. Over 1.3. Yikes. 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 Losing over 100k is easy. That's over 100k disappear from your account. No returning that. That's lost. You just say goodbye to that one. Mommy was getting put in a home and you was giving mommy up there. That neighbor ain't gonna pay back his cent. I don't know. We'll see how that goes. Good luck for that one. No, for real. Good luck. Alright, it seems like Ria is out for the evening already. So let's get into a further discussion. Do you think that the young lady who was expelled got proper due process? The schoolgirl that got into the fight and the stabbing incident occurred, do you think she got her due process? I am unsure about it because they expelled her on Wednesday. The expulsion came down on Wednesday. The incident was Monday. The girl's father is saying that they have not even spoken to them. How can you adjudicate an incident, expel a student without fully investigating the whole thing. I've seen in numerous places people say that the young lady who had the knife was the person who was actually bullied originally. And there are several reports to corroborate that. And the ministry, in their statement why they expelled her, said that she was also receiving assistance and intervention from the student support services or something like that. So maybe there might be even a record of her making these complaints. I've heard many people point out that she had a knife, and a knife is a deadly weapon, and that is very true. A knife is very deadly, and in close quarters, in some cases, knives could actually be more deadly than guns. So yes, I agree, a knife is very deadly, and why would a girl bring a knife to school? But I think back on school days, and I find many times when adults look back and make judgment and pass judgment on school children, sometimes they refuse to put themselves back into the school days shoes. They refuse to put themselves back into that place. And I think back on myself at the age of 50. The kind of rebellious spirit you could feel bubbling up in you. How you would treat with being unfairly treated. How you would treat with being frustrated. Children do not handle frustration well. Was she supposed to take beat up from a group of girls? Is the question Tony the ambassador is asking. Good question. If she didn't have the knife, she might have been in the hospital. And I could think back on myself at 15 years old, and I feel like if I had a conversation with 15-year-old me, and I asked me, listen, if a group of people said they're coming to beat you up, and how it goes many times in schools, that fight may have been warned about and promised about before, because the young lady and her father said that they warned about it that very same day, and she was threatened that someone is going to shoot her, etc., etc. So if someone tells you, hey, I go and beat you up Monday when you come to school, Monday when you come to school is me and you, and I beat you, I go and kill you, I go and shoot you, etc., etc., Monday is me and you. Well, you might be thinking, well, I'll pick up my kitchen knife just to protect myself. And if you're being honest, I can remember back in school days, and there were some people who walked with knives who were not always the biggest bad boys in the school. And I'm not condoning it either. I said that at the very beginning. A knife is a deadly weapon. A knife is a deadly weapon. I could never say I'm condoning that. So, however, the Guardian article that initially broke this story said that it was multiple people beating one person. If multiple people were beating one person and the one person made complaints before about this very same thing, and then you allowed the very same thing to happen, I think some mercy must be extended to the resulting actions that were partially a consequence of your own inaction in the system. I used to walk with a lock and put it around my knuckles. It's not unheard of. I know some young men used to have the hockey stick tucked in a little corner by the school fence. You know about that because it could be a war zone out there. People acting like if they do not understand this. Now, I am saying I don't know the full facts of the situation. The reality could be that none of that what is being said is true. It is far from the truth, and okay, fine. If that is true, that is true. But I think it is something that needs an investigation. And obviously, if what the girl's father is saying is true, they haven't even spoken to the young lady yet, so obviously they haven't completed an investigation. How can you expel her? Announce you're expelling her across the nation and haven't yet done an investigation on the matter. I don't understand that. I don't agree with that. Now, there may be some part where either way there might be some consequence that needs to be done, even on the girl, even if it was self-defense, because it's something that's significantly violent, and in school uniform you could understand wanting to take measures. But if it is a case of self-defense over an a lengthened period of harassment, then the intervention should be something more along the lines of counseling and protection. Listen, I feel if you allow every student in school to be pummeled upon repeatedly, eventually a large percentage of them may do things just like this. Lack of intervention at times when you can is going to lead to situations like this. Like the father who released some hand on the youth man who allegedly assaulted his daughter numerous times. If the system keeps failing, obviously people are going to take matters into their own hands. What do you expect to happen otherwise? I don't like how that was done. I don't like how that was done. Well, come in now, interesting. Come in. I want to see how this whole, how I'm going to function here with the live, if the discussion is going to be picked up well on the mic, and see if it transposes to the YouTube live too. So come in, I don't mind. We'll try it out. She ain't no fighter with a knife. She still didn't cause much damage. 3 centimeters. She was just trying to stop them. Roni, that very same thing you just said was something I was thinking about. When I was reading the now let me make sure the mic is in a position to catch some of that volume. Yeah. When I was reading the realities of the case, and they were saying that she got a gash from the eye to the lip. She got a slice on her shoulder, I believe, and a 3 centimeter gash on her chest. And a centimeter isn't that big. And I thought, I don't, it's not like I want to say, oh gosh, it's not that bad and you got attacked with a knife. But 3 centimeters, that seems like somebody who has some apprehension. If someone, let me put it this way before it sounds too bad. If someone is interested in causing you significant damage with a knife and they had 3 goes at you, I think you would be significantly more damaged.
Yeah, they can kill it easy.
Yes, they can.
And when you take into consideration the numbers that you hear in the story,
Yep.
so is that savage, right? And for her to come with the weapon in hand means, should have understood beforehand that this is what the situation would have been.
Mm-hmm.
Me, by myself, the numbers are against me, and all I have is to protect myself. This is what I'm working with.
Yep.
And I do not believe it's not a situation that she would have, or she would not have raised some sort of alarm regarding, because situations like these don't just happen. You don't just come to school one day and then is a squad come to beat you. Right? I could give you a story, and this was my personal experience. Right? Back in school days. And there was this guy, he was a bully, like the beat people, take their money. And he didn't used to target anybody in particular. Whoever he feel he could really bully and get away with,
Mm-hmm.
then he soft target if he could. And I was always a short man. And it just so happened that it came around that it was my turn in the chamber. That probably was about a year or something into the school. I was just fortunate enough to evade him up until that time. But then when his sights were set on me, it was like, basically, your turn, I didn't take your money yet. Let me see what could happen. But I was real different in school days. I had that kind of mindset. Not that I consider myself a violent person or nothing like that, but I absolutely insist you're not taking my money. Other persons, a lot of times bullies used to rule by fear. So sometimes I beat you. I only need to beat you once. The next time I pass, I ask you for the money, because if you don't want to get and do so away again last time, you just dip in the pocket and give me part of least resistance that I will be looking for to get the money. Well, not me. I make up my mind. If we had to fight 5 days a week, we're fighting 5 days a week, but you're not getting my money. And so said, so done. And I was a A student. I prefect at that. You understand? So it's not to say like I was out here looking for trouble, but the minute he had stepped in, because the day did come, and he tried to take the money, and it was a big brawl. But you know what? The difference was, is he only ever tried once. I never tried to take. He wasn't successful, eh? Yeah, gave him a good fight. And after that, he never tried a second time. So for the persons who would want to criticize his girl for defending herself, is not to say like I could understand it, even though I don't know all the circumstances around the situation. Look at the information that we have. Is how much of them against her was 2, 3 on 1?
I think it was 4.
4. You making joke? Sparrow say 10 to 1 is murder. Granted, it can make 10, right? But it's 4 on 1, right? And if she was 4-1, that this is what the situation would have been. I tell you, anybody in that entire situation is not the person who was stabbed would have been the most afraid in that situation, but the person with the knife. Because you're watching 4, even though you have that knife on you, you are the person most afraid, because that is the reason you came with your weapon. You didn't come because you're bad or you're malicious. You come because you're afraid. And your worst fears came to life when 4 of them attack you. And like you said, that gash, there's a coward choke that results in a 3 centimeter. Because if somebody have malicious intent, you live with a function.
That is something I was seeing too. And I remember when I first, I can't remember if it was in a live or a story I was doing for the YouTube regularly. And I first read it and I read that 3 centimeters and I did this on my fingers. I was like, 3 centimeters is like, because what I telling you all, I said it in the original. I never looked at the video itself. I don't like that kind of thing. When people tell me a young girl stab a next young girl, I'm not interested in seeing no little girl bleeding. That doesn't give me any kind of vibes really. Not my cup of tea. So I didn't see it. But I was thinking is something drastic. And the article talk about the lungs being monitored and thing. So, but then they say 3 centimeters. I like... And then the gash on the face was a gash of... that is what it is. I remember I went to school. And there was some stabbings back then. And when the real stabbers do the stabbings, let's just say it's not 3 centimeters. I am not saying I wish it was worse than that. You know what? I am very, 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 very happy that she did minimal damage with the knife. I am very happy. I would have been more happy probably if everything is true and she pulled out the knife and just by wielding the knife alone she scared off the people. But it seems so unfortunate that so regularly in the system it seems like when you're the one to defend yourself, you're often the one to be punished. Like uncle who hit the youth man some tap and now he being charged.
On Nathan.
Yeah.
Here's the thing, right? I agree with people when they say, you know, it was advantage thing, and I hate bullying. Like, it's tell a primary school fella who tried to bully me when I was young, and it was always something that I hated passionately, right? But the fact that this interesting, right, mentioned earlier that that was a frightened choke.
A coward choke.
A coward choke. That speaks to the fact that she knew that she was doing something wrong, right? No, I'm not against defending yourself if you're being bullied.
You know what I meant, eh?
But the method.
You're afraid for your life is for them.
Right, but the method.
You are afraid of them.
Right. So what I'm saying.
What you was going to do. You are afraid of them.
That's not what I'm saying. I consider this the method in which she used to defend herself was callous, over callous, and worthy of facing a consequence. Because one could simply look at it from this angle. She could have used found a wood, a piece of metal or something that wouldn't cause as much harm as a stabbing.
Nah, man. I disagree with you there too, Kevin.
Hold hold on. No, even though, hold on.
Finish. You finish.
Even though it's a 3 centimeter stab, right? And it to some it don't seem that bad. But this girl now, she has to live with that scar on her face.
Correct.
Which will cause emotional damage, right? Self-esteem issues. Now she herself could become a violent girl, more of a violent child, right? Because she was bullying, right? She could even have suicidal thoughts. God forbid, of course. God forbid, knock on wood, right?
Yeah.
So it's not just a 3 centimeter stab. It's not just a coward choke. It's a lot more that comes behind the whole act that was committed. So the fact that she carried this knife, as much as she knew that these people was going to bite her or beat her up or threaten her, whatever the case is, the act was premeditated. Right? She committed a crime which was.
You can't say that. You cannot say that.
Just now,
All you know that.
let me see if I could come in here now, because
Oh wait.
let me.
For all you know, the purpose of the knife.
Just now.
For all you know, the purpose of that knife could have been intimidation, and I'm hoping that she did not have to use that. The premeditation would have been the threat of damage to her that caused her to want to put measures in place to defend herself.
Right.
Think of it, eh?
So if think of it this way. Think of it this way also. If she brought the weapon, to me, the fact that she brought the weapon actually gives some credence to her story that they were threatening her and she was afraid and she kept telling people about this. How can it be? Because her father said that she told the authorities about it that same day. How can it be she told them about it that same day and she reached out the road, right out the road from her school, and a gang of girls beating her up? And then we will look and say, you know where the real fault is here? In this girl who was scared for her life, she choosing to take a knife and defend herself. You know what? She should have gotten a 2x4. A girl, a young girl, 15-year-old girl, should have gotten a 2x4 and swing it at a group of people trying to beat her. Let me tell you what would happen. If a group of people are trying to beat you and you are a young woman, do not pick up a 2x4. They will take the 2x4 from you and they will beat you with it. The weapon is the strength evener. That's the purpose of a weapon. So it's like when people talk about someone had a knife and the defensive person had a gun, and they're like, but why you shot them? They only had a knife. That's the point. I want a stronger weapon than the person who is attacking me because I want to deter them from attacking me. I am not attacking them. If they are attacking me, I want a stronger weapon. And if you are thinking of this from the girl's perspective in terms of protecting herself, she is currently out of the hospital. Okay, granted, she's out of a school too, but she's out of the hospital. That might not have been the case if she didn't have a knife. If she had a pencil, if she had a wood, if she had a piece of iron, if she had her fist, all now she may have been in the hospital herself with broken teeth, disfigured something, or she could have been worse, because we know now that they are close to passing out each other in some of those fights. And then we'd have said, oh gosh, look at this poor girl. To be honest, I rather say, girl, learn to temper yourself and escape those situations than say, oh gosh, look at this poor girl die, they beat she to death, you know. I rather say that any day. And to me, when someone is defending themselves, I find it hard to try to point at them and critique the amount of force that they used. If you hold somebody by their neck and they swing around and punch you in your temple and kill you, you could say, oh gosh, the man was just holding him by your neck, you could have pushed him off. But you were the one who aggressed on the person. If you didn't put your hands on someone else, you would not have put yourself in the position to let that happen. Listen, if all the facts of this case is correct, in a different jurisdiction, a different place in the world, some places in the United States, that young lady could have been dead and the young lady who did it might have been innocent because she aggressed upon her. And All right, I agree. The fact that she brought the knife, she's getting the two charges she's getting. She has been slapped with two charges, I believe, assault occasioning grievous bodily harm and the possession of a weapon with the knife. I agree with the possession of a weapon charge. Any day, granted, that was not right. Possession of a weapon charge. True. But I think even the possession of a weapon charge, as I said, is an indictment on the school system. This young lady was afraid enough to know that they were coming for her that day to walk with a knife. This wasn't even a Friday evening. This was Monday. But it seems like she was aware that they were coming for her enough that she could have walked with that weapon. Bear in mind, she was able to get in and out the school with that weapon, just by the way. So, all how this is an indictment on the school system. This is an indictment there. If you leave my child, listen, if I have a child in the school system and he is being bullied and you are not doing anything about it and I am not privy to it, I will not be surprised. I will not hold my child as some big guilty party if they do something about it. They are a child. They respond to frustration differently. They will act out if they are being cornered into some spot. I don't understand that.
Let me just say this before people screen record and want to put some kind of different narrative. I was just looking from a different angle, but I not blaming any not blaming the girl who do the stabbing or anything like that. But what I would say though is I agree with what you say, she's facing some type of consequence because the scenario was unfortunate.
Yeah.
But yeah.
I believe her attackers should face some consequences as well. Some serious consequences. They should not get away from this one's case.
I am waiting to see that now.
If not for them,
if
not for them, this would not have happened.
Here the thing interesting. This thing kind of touchy. I'm not going to go on any public platform and call for consequences against a 15-year-old girl who is presently hospitalized. The reality is, I don't know for a fact what was happening before. If it is true that she was the bully and that's what happened, then the least that could happen is she has to be expelled too. In fact, every single girl who was beating up the other girl also needs to be expelled too. I am not even saying I want this per se. I am saying that the standard the ministry has set by expelling the one girl already, to me that's the standard they have set, so everyone involved must have that happen too. Otherwise, this will not be fair. That's unfair. You're telling me it's best I be the bully? It's better to be the bully then.
Yeah, because I'm telling you, this situation is happening in schools all across Trinidad and Tobago. This one only getting airplay because the bullied in this case stood up for herself in a way that some may call inappropriate. And which I agree with, don't bring the weapon, but the principle is the same. She stood up for herself and she tried to use an equalizer so that she wouldn't be demolished going up against a team 1 versus 4. This is something that's happening right through. And so if you set this standard now where the real victim, because they happen to, mount a credible defense and damage one of their attackers, right? So they face a consequence for it. Then what does that say for everyone else who is bullied across Trinidad and Tobago? Don't defend yourself too hard, because you end up getting thrown out of school.
You see, to me, like if I am a parent in a situation like that, the advice to a child is you still have to do what you must and face the consequence there. That's why I said I don't necessarily have a problem with her facing consequences, because it's something that it's like if you were in a Catholic church and if you were in some religious institution somewhere and a priest attempted to do something and you punch him straight to face, like he touched you a little and you cuff him in the face, I mightn't tell you you're wrong, but I am going to say nonetheless you are still supposed to be charged with assault. It's just that you doing an action may be fair for the action, but okay, yeah, you still have to face the consequence of it. It's like some of those protesters. If you go protest and lock yourself on top of the Prime Minister's car for some good reason, let's say you have a good reason for protesting that, I might say, okay, I understand it's a good protest, but nonetheless, you're still supposed to be arrested for it. So sometimes that's the fact of it. Sometimes it's like if you have a teacher who is insulting you in a class and you back answer them, you reply to them. If I'm your parent, I might say, okay, that was a good reply, but nonetheless you may have consequences to face for it, and that's just the reality of it. Now in this, and I think this might be a bit of the brutal reality, if you're wondering about the consequences of an action, an incident like this, let's think of the fight as an incident in your life. You're either one of the girls. An incident in your life, this big fight. Would you rather, as a female, have a scar from your eye to your lip and 2 other places on your body, or be kicked out of the public school where you were being bullied anyway, and according to her father, she's going to go to a private school, she's already been accepted some places? Would you rather go to a private school and very likely she's going to get some kind of community service out of this or something like that, if anything? Would you rather go to a private school without scars, or remain in your school with permanent scars on your face? And if you were someone looking at this situation even from the beginning, and you wanted to choose one out of the 2 girls to be, which one do you think you would have been? And in terms of that, I understand this could sound weird, but I hope you all, and I know you all, my audience, understand the context. In terms of that, was what she did successful?
Well, she wouldn't be bullied anymore.
And she didn't die, she didn't get a scar, she wasn't hospitalized, she's not going to the school where she was being bullied. I find that... Alright folks, the rain coming down. I looking to head out there. I'm gonna see how this live run with the YouTube and the mic and stuff, because I was still running on the YouTube, just by the way, with all the recording. If it ran well then this is how the live structure will take more of, where we could actually interact some more even on the YouTube live. So we'll pick up Monday for the next Mindful Live. I hope you educated, informed, or entertained, and peace out everyone. It was nice. See you all. Laters. Watch the movie What Is a Woman? You know good movie, Richard Globe, man. You know good movie. I am into that kind of stuff, man. Daily Wire, yeah, all that.